This video concerns Iowa workers' compensation, and what I'm talking about today are the issuance of warnings by employers. And this is probably not a video meant for employers who already have warning notices or have legal counsel to guide them through the warning process. Let me give a disclaimer first. First of all, this is a non-profit video, not sanctioned by Workforce Development nor by the state of Iowa. This is with all volunteer time. This is legal information and not legal advice. Now, in unemployment compensation cases where you have a discharge for misconduct as an issue, warnings are usually quite important. And one of the things that every administrative law judge will ask about is whether the claimant was given warnings before being fired. And what I want to do is go over some of the basic elements of an acceptable warning notice. Now, if you already have a warning form, I wouldn't change it to match up with this. I think what you need to do is take this with to see if there's something that you might want to change, add, or delete, depending on your policies. Many employers do not use written warnings, and this is usually a mistake when you come into an unemployment hearing. And the most common scenario is the employer says, well, yeah, I told them that if they were late again, they would be fired. And the claimant says, you never told me that. I don't remember that. That didn't happen. And that's why written documentation created contemporaneously with the event, close in time to the event, is important. So let's go over what a warning should have, or what a warning you might want to consider putting in your warning, a written warning. When you create a form, it's good to have a nice generic form so you can use it for all types of situations. First of all, give it a title. You can call it a warning notice, or you can call it final warning, or just warning. There's a number of things that you could use for naming your document, but the word warning really should be there because that's what it is. You certainly want to have a place for a date. You want to fill in the date, and you want to put a to what name of the employee, whoever the employee is, to John Doe. In the first line, you could state this is a formal warning. That way they know exactly what this is about. It's a warning. Or you could, in a situation where you don't want the conduct to happen again, you could say this is a final warning. Then you would go on to explain what date that the incident happened. For example, on such and such date, you violated policy by coming to work 10 minutes late. So a brief description of what happened, what the policy violation was, whether it was a safety policy or attendance or whatever work rule, and then go on to say how you know. And it's good to put in this document and maybe even attach to it how you know. For example, if the employee punched in 10 minutes late, you might put in a copy of the punch card. If you have some other infraction where it was observed by a supervisor, the employee was not properly performing their work on a production line, you could get a statement of the supervisor signed and dated stating that they observed the employee violating procedure, and then you could attach a copy of that. And the reason you want that is that in the future, if you ever want to refer back to this, the documentation's there. And you don't need to be real verbose. You don't need to have a lot of information. But attaching whatever it is that proves your case is important, or at least saying in it, you could just say, Supervisor Smith saw you arrive to work and punch in 10 minutes late. And then you know why and what happened. Now the last part, I guess the second to the last part that I want to focus on is a generic warning. Now there's many ways you can give warnings. You can say the next incident will result in a written warning or a suspension and so on. But the one that works the best for most employers is simply to state that, up to and including discharge is the next violation. And here's the reading. Further policy violations shall result in progressive discipline up to and including discharge. Let me say it again. Further policy violations shall result in progressive discipline up to and including discharge, end quote. In that way, the employee knows that the next one could very well result in discharge, no matter what it is. And that kind of gives the employer the discretion then if something else comes up that's really, really serious, instead of violating their prior warning, they can go straight to discharge on it. Because another fact pattern that occurs is that employer gives a warning and saying that on the next incident you get written up, you get a written warning, and then something far more serious occurs that, and you look and it says written warning isn't warranted. This is a discharge. It should be discharge on this, but you have this pesky warning laying there that says, well, the next time you warn them, you give them written warning. So this kind of phrase usually covers all categories. So you have discretion to discharge, or you have discretion to keep the employee and do something less. Because the objective of warnings is not to get people fired. It should be to change behavior and maintain a good employee. Because most employers understand the cost of rehiring and training is quite expensive, and it's far better off maintaining an experienced employee, even if they are average. And finally, and this is another area that I see misused. There's usually a signature line on written warnings so that the employee will sign it, and employers try to interpret that as an admission to what was said in the warning. And usually employers should not try to do that. They should simply use a signature line for the employee to acknowledge that they received the document, that they received the warning. That acknowledgement is important. It's more important that that you prove in an unemployment hearing that the employee was on notice that the next incident would result in discharge than proving the prior incident. Because in unemployment, in a discharge case, it's the final incident that can disqualify from unemployment. And you can have 50 prior warnings, not one of them can be used to deny someone unemployment benefits. But they can all be used to prove that the employee knew they were in trouble and knew that the next time they're fired, so as to establish an intentional act or a high degree of carelessness. You're putting the employee's state of mind as evidence by letting them know they knew darn well that they were going to get fired in the next incident. So generally, on your last line, or a signature line, you should have something like, I acknowledge that I received a copy of this warning. And all the employee does by signing it is saying that they got a copy and they know what it is. Or I acknowledge that this warning was read to me. There's a lot of employers don't even give them the copies of the warnings. They simply read it, they sign off on it, and it goes into the file. Now, who else signs off on it? You certainly want the supervisor or human resource manager sign and date to show that that was issued to the employee, and preferably a witness. Because one of the last things that I want to talk about, one of the more frequent occurrences is employees refuse to sign these documents because they've heard the horror stories of, well, they signed the document, you're admitting it's true. And the employee is still contesting that it didn't happen. So in the situation where an employee refuses to sign, then the employer simply writes on the employee line, refuse to sign. And then the issuing supervisor or human resource manager can sign and date it, and the witness who is also in the room signs and dates it. Now you got it backed up by two people, and you have a valid warning, a valid written warning, and that's good evidence at the time of an unemployment hearing. So written warnings, I think, are probably the backbone of a discharge for misconduct cases. Employers should always keep copies of written warnings and issue written warnings when infractions come about that they find serious. Now, I want to talk just a bit about embezzlement, employee theft. And I'm going to do a video on this, but I'm going to give you just a tidbit, because when employers see a change in employee attitude, that's the time to take action. And you don't take action by calling in all the employees and saying, don't do this again. And this is a common mistake that small businesses do. If they have an employee chronically coming in late, they call all 7 of their employees in and they counsel all 7 at the same time, don't come in late. Well, only one was coming in late. You don't counsel a group for one person's infraction. Do these things privately with a supervisory witness. That's how you issue warnings. Group warnings are weak, and they they don't hold up very well for unemployment purposes, because discharging someone for misconduct is a higher level than negligence. It's not just the right to discharge. Employers have the right to discharge employees for practically any reason they want. Misconduct is meant to be a much higher standard. You have to prove something intentional, something of a high degree of carelessness. So calling in for group warnings, that doesn't cut it. But watch employees for change in behavior. When you have someone, especially in the white-collar business, I see this a lot in dental offices, where an office manager comes in with a change in attitude, is not treating patients appropriately. You can see some issues where billings are going down, aging reports don't look right. Get to the bottom of it immediately. Don't use the excuse, well, I'm just here to practice medicine, or I'm just here to practice law, or I'm a great artist and that's what I was meant to do. Sometimes you got to be a great doctor or a great lawyer or a great artist and a personnel manager, because it's a business. And when you see a change in employee attitude, quite often that goes hand in hand with theft and embezzlement. Investigate immediately, get to the bottom of it, help preserve the employment relationship, or find out that there's something going on and then figure out a legal and appropriate ethical way to terminate the employment relationship. So change in employee attitude is a big factor, and most employers know what's going on and they just ignore it because they're too busy running their business. Don't be that employer. A future video will go more in depth into warning signs for embezzlement. Thank you and good luck with your unemployment claim.